Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI, #Web Policy Learning. Today, we are gathered here for Day 9 of Law and Public Policy Youth Fellowship, an online National Summer School program, a 2-month online immersive legal awareness and action research certificate training course, and internship program. This program is organized by IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow IMPRI. The distinguished experts include Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Wahida Nainar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey Di Mello, Dr. Kaustuv K. Bandopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Ghuge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadip Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sangamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N, Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, effort, and energy into truly understanding the vital role and complex intricacies of legal and public policy frameworks. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and pace. Before we start today's session, I would like to announce the housekeeping rules. First, it is imperative that you join the meeting on time. Second, there will be a Q&A session after each presentation. Third, share your questions in the Q&A box and not in the chat box. Fourth, the questions must not be posted as an anonymous attendee. Fifth, ensure that your questions are precise and refrain from making general comments in the question to save time. Our session for Day 9 will cover topics of first, Social Security, Law and Public Policy by Professor Aruna Roy, and Inclusion, Laws and Policies 2 by Advocate Dr. Albertina Almeida. To start the session, I would like to invite Professor Vibhuti Patel for her opening chair remarks. Ma'am, over to you.
Yeah, thank you. Thank you, Shweta. And first of all, welcome Professor Aruna Roy, Dr. Nikhil Roy, and also I would like to thank IMPRI team, Dr. Arjun Singh and the team. Today is the third week and ninth session of the online course. We all began on 12th of June with a presentation by Mr. Sandeep Chachra of Action Aid, and he introduced the participants with the macro perspective. He gave several examples of people's participation in policymaking and legislative reforms. In Day 2, we had Dr. Wahida Nainar, who acclimatized the participants with international human rights instruments, their application, impact, and relevance. In Day 3, we also had, and in between, we also had many hands-on exercises by Dr. Shalu Nigam. On Day 3, we had a session on law, economics, and public policy by Professor Mukul Ashar, who showed the limits and the scope of public policy. Day 4 was about the policy initiatives and role of Indian judiciary, where Professor Uday Shankar spoke about the two approaches, two schools of thoughts regarding the power, dealing with power, the power of executive and power of judiciary, and where do we draw the line. He also talked about environmental standards, role of National Human Rights Commission, and when state is a litigant, what are the predicaments. Dr. Uday Mishra from Media Indian Express, he spoke on law, public policy, and media role of media, and he also gave several examples of his personal involvement at a field level journalism, and where he said that the role of a journalist to bring out truth, and truth and if truthful reporting takes place, we can bring a lot of transformative changes. He also talked about the models of media houses, where he appreciated BBC model and model of Guardian, where the public support is ensured. And in India, Tribune from Chandigarh is also supported by the trust. Day 5 was about public interest litigation, where Dr. Shalu Nigam gave several examples of public interest litigations filed by civil liberties organization, democratic rights organization, and also role of public interest litigations and judicial activism in changing the scenario in terms of legal reforms and also changing the grassroots reality. Dr. Nivedita Haran spoke on public policy processes, which special focus on political and social culture within which public policies and legislations are placed, importance of data, adequate and authentic data, role of efficient and non-corrupt governance, financial situation, the budgetary allocations of union budgets, state budgets, and PRI budgets, and efficiency of public services. These are the very important features. And she also gave her own example of involvement as an IAS officer in Kerala state. Day 6 was by Sri Bhatendra Singh Baswanji, who had a very, very long interactive session with the participants, where he talked about the what drives the public policies, and also he also gave the whole historical unfolding after the Second World War in global geopolitics and diplomacy and the developmental efforts of India in a post-independence period, and the changes that came after adoption of new economic policy. This Day 7 was by Dr. Purnima Chauhan, who reflected on urban local governance practices, where she shared her personal experiences of being a secretary in Himachal Pradesh and how they address the question of declining child sex ratio in the border areas of Himachal Pradesh, and also the question of implementation, women's involvement in implementation of Rajiv Gandhi Awas Yojana, how it changed the whole scenario, and the people's participation was ensured, and people are using those houses. She gave several successful examples of, say, Sweden, where the urban local self-government is playing a very, very proactive role, and people's participation is ensured. The presentation by Dr. Albertina was on inclusion, laws and policies, where she unpacked the reservation policy and its implications. She discussed in a very, very intense narrative. She discussed Dr. Payal Tadvi case, Rohit Vemula's suicide, and also the Atrocities Act of Scheduled Caste and Scheduled Tribe Atrocities Act. And also she said that the reservation has to be proportional to population. Dr. Shalu Nigam's interactive session was about the torture and how the freedom of expression is very important, and how we need to, and what are the learnings of farmer struggle against 3 farm laws. And she ended with the Rabindranath Tagore's poem, Where the Mind is Without Fear. The previous session, where Dr. Shalu Nigam provided intense narrative on navigating criminal justice system and explained the processes of dealing with the justice processes, and also after that, she also ended with the feminist concept of gender justice evolved by Nancy Fraser, where she talks about the trivalent model, which would include gender representation, gender recognition, and gender inclusive redistribution of power. And last session was by Dr. Gladstone Xavier, where he covered the huge canvas of the conflict and peace building efforts, peacekeeping, peacemaking, and peace efforts at a global level. He also discussed examples of Sri Lanka, Afghanistan, Indonesia, and he also talked about the syncretic tradition of Indonesia. And he concluded by stating that diversity is the strength, unspoken, untold struggles of the people that we need to bring to the fore so that people get optimism. And different countries have different models of peace building, and the contribution of social work in creating evidences for policy, for public policy formulations, legal and a legal architecture, and the reforms and judicial implementation and evaluation of all these policies is very important. And universal thumb rule must be morality of coexistence. Thank you very much.
Thank you, ma'am. We have Professor Aruna Roy, who will be taking up the session on the topic Social Security Law and Public Policy. Professor Aruna Roy is the President of National Federation of Indian Women, NFIW, and founder of Mazdoor Kisan Shakti Sangathan, MKSS. Welcome, ma'am, and over to you.
Thank you very much. My real preoccupation has been with poverty and with livelihood and with looking at the condition of people who are on the margins, who have not ever realized their rights that have been given to them with sovereignty and the Constitution. My life of working with people is over 55 years. But in those 55 years, 50 years I've spent in rural India. So my concern has been how the people who are looked at as receivers of charity, receivers of welfare, receivers of plans, implementers of the details of big plans that are made by the government, are never consulted on what they need and how they work. And actually, there were two important issues that came in the way of the understanding of their plight, and that had to be removed. One was that they continually complained of corruption and the non-delivery of services, and the other was that what their actual needs were in priority. Policymakers and government planning never considered really seriously. And in allocation of funds, they were really given the most marginal of funds, the most minimum of funds, and actually expected to improve themselves despite the fact that India declared itself a welfare state. And with the first plan that came and the setting up of the Planning Commission, we really decided that we would look at planning as a mixed economy, where half the work of planning would fall with the state and the rest with the private sector. Not half, more than half with the state, and some amount of it with the planning sector, with the private sector. But in this entire position that we put ourselves in, we thought that we knew, as researchers, as planners, as politicians, as government servants, as IAS officers, as professors of economics, whatever we have been, that we knew what was best for the country, and the poor people were just beneficiaries, targets, or receivers. My experience with the people of India has proved just the contrary. I feel that there's huge amounts of knowledge, understanding, and a perspective through which innovation can be made and a new kind of planning can be done for the betterment of people. So when I think back on what happened to India, and I remember Dr. Ambedkar speaking on the 26th of November, 1949, made his famous statement on the challenge India faced. And he said, because of entrenched social and economic inequality, we would have to build a social democracy and not just a political democracy. He insisted that with the Constitution, we were only guaranteed one person, one vote. But what about the rest? He raised this question to us. What about economic and social reality? So when we go down and see Articles 39, Articles 41, Articles 43 of the Indian Constitution, it says the state, in brief, it says that whether it's public education, whether it's health, whether it's any of these issues that are now considered welfare, whether it's livelihood, whether it is workers' wages, with agricultural workers, whether it's industrial workers, and all these conditions of a decent standard of life and full enjoyment of social and economic equality should be assured to them. In the early 90s, when the Mazdoor Kisan Shakti Sangathan was set up, by the way, I've been many things before that. I was in the Indian Administrative Service for 7 years, from 1968 to 1975. I worked with an NGO from 1975 to 1983. And in this entire period, I worked, the most important thing that happened to me was that I listened to people. So I listened and I worked with people, I lived with them. I did not live far away in middle class comfort and privilege and go and visit them every day. I lived with them, I ate with them, I slept with them, and I realized that the most important thing that is missing is the sense of equality that we do not give to their minds, their understanding, and their capacities. And in skills, we only put literacy. We do not understand that there are other skills that are extremely important in life, whether it's agriculture, or the crafts, or whether it's weaving, or whether it's understanding the mechanics of existence. There is a great amount of skills that are there in the village. So to cut a very long story short, because I worked for more than 50 years, we worked with wages. We won a huge Supreme Court case. It's a landmark case. It's called Sanjeev Roy versus the Government of India, in which there was a decision that workers' wages could not be less than the minimum wage, and there could be no differential rate for women and men or for workers on one work site or another work site. They struck down parts of the Famine Relief Code of Rajasthan. A huge amount of people got involved in the understanding of minimum wages. But everywhere I went, no matter what work I did, the one thing that people wanted was work, and they wanted dignity. And it's amazing how much of a difference there is in the perception of their life. We sit here, wherever we are in privileged lives, and think of them as people who take a dole or receivers of our largesse. But they don't want that. They want dignity. They want to work, they want to earn, and they want to be masters of their life, mistresses of their life. And they want to plan a life that is full of dignity and of self-assurance and self-reliance. And I have learned most from them. I studied in Delhi University. I learned a lot from my professors. I went to the IAS. I learned a lot about governance. And I spent the rest of my life with people, and they have been my best teachers, my best professors, my best planners, my best policy makers, and the people who cut the chaff and go directly to the point, and you know exactly what they want. And if you talk about delivery, they tell you exactly what will deliver and what will not deliver, much better than an IAS officer ever can. So when we started protesting against corruption and against arbitrary use of power, in the early 90s, the MKSS started looking at wages and non-payment of wages, and we discovered that the non-payment of wages was because of corruption within the government. We started asking to see the papers of the government. We were told they were secret documents. So we started this massive campaign for right to information, which became a huge thing. And it's MKSS's gift to India, that right to information law. So this law, the conception of the law, came from very ordinary people. Actually, I would have used, as I'm doing now, highfalutin words to describe how disclosure is important, how this relevance and it improves the sovereignty. But my colleague who's passed away, Mohanji, he sang a song. He was an illiterate man, but he was a poet and a bard. And he was a politician and he was a theoretician, but he didn't have literacy. And he sang a song which said, "Pehle wale chor to banduk se marte the, aaj ka chor te kalam se marta hai desh choron ka." And in those 3 lines, he conveyed to the entire people the reason why we are not getting our entitlements, because our entitlements are being thieved. It began with that, but as a result of that, and it's a very long campaign that took place with the RTI, we first understood that we needed 4 things. We needed transparency, accountability, we needed public audit, and we needed redress. And with these 4 things in mind, we started looking at what kind of forum can give us this. And we stumbled on and created what is now called social audit or public audit, but it was through a process of public hearings or Jansunwais. When people come, you share information with people, people absorb the information, they come back and they depose and they testify as to what's wrong with it. We invited the government to be participant to it. The government sometimes came, sometimes did not come, but there was a huge number of public participation, and there was media. And media also reported on it. At that time, the media was much better. Media reported on it, and it became big news. So much so that the Chief Minister of Rajasthan in 1994-95 made an assurance in assembly saying that photocopies of bill vouchers and muster rolls in panchayats would be given to the people of Rajasthan. When he didn't fulfill it, we went on a big campaign and a protest, and that protest led to the campaign of National Campaign for People's Right to Information. The campaign demanded a law, and the chief of the Press Council of India, Justice Sawant, was requested to form the law. He formed the law, and across sectors people joined, because by the time the struggle for actually getting the wages, of getting rights to see health records, getting the rights to see ration records, all that was going on. And then the campaign took it to various states where we discussed the whole nature of transparency and how much it would impact all sectors. So lawyers joined, researchers joined, women's joined, Dalit groups joined. I mean, everyone who was anywhere wanting to get justice and access to information for justice joined. Actually, the right to information law was drafted by people. It was not drafted only by Justice Sawant either. He took information from us, but he put it into legal language. So all the points of relevance came back to us, and he would say, test this with the people, see if it's what they want. And we put into it all that we wanted, and that's how the law became a people's law. So when in 2004, the government came to power, they had come with an assurance that they would give us a right to information law. The previous government had passed a law, but it was completely ineffective. So they promised to give us a better law. So the right to information law was as a promise in the National Common Minimum Program, which they published as a set of promises to the government, to the people of India. So the National Common Minimum Program became a commitment to policy and law by the state to its people as a response to our demands on what we wanted. And as a response to that, we got the right to information law passed. We also had MGNREGA passed. So the demand for right to see records was on employment sites. So the whole question of demanding a right to work also became part of the campaign. We started looking at right to information and right to work as two sides of a coin for poor people. So we started working on right to work. We went back to Maharashtra's employment guarantee scheme. We had a look at it was an extraordinary act in its time, and it also made very good provisions for money. If you ever have time, you should read it. It's a very good act. But anyway, it had its limitations. So we took it up as an issue. We discussed it all over the country with very many groups that work with poverty and with poor people. And it became completely clear that that was a demand across India, pan-Indian demand. And all that it required, at a rough estimate at that time, was less than 4% of the GDP of India. And all the economists who are right-wing economists who thought India would only prosper if there was a pot filled on top and it trickled, and it never trickles, that trickle and the drop would make the people survive. I'm sure you all know about the trickle-down theory of economics, but the trickle never arrives, the trickle stops somewhere. All the holes in the pot are already filled. So there's no water that trickles down. So in that context, it became absolutely necessary for us to fight for this as an economic right, as a fundamental economic right, again linked to those three articles that I mentioned, the article, the right to work, the right to survive with dignity, which is guaranteed in the Constitution of India. They drew strength, as I said, from the directive principles of state policy and the fundamental rights of the Indian Constitution. But people became aware, and what was amazing, but people connected the dots from the demand in the Panchayat to the Constitution of India, from the Panchayat to the Panchayat Samiti, to the district, to the state, to Lok Sabha. They understood what the Lok Sabha meant, the political involvement and the political empowerment, even ordinary illiterate women, was extraordinary because they understood how democracy should work. So the notion of participatory democracy became established. And it was a very big demand, along with the other demands, that we shift from representative democracy, where our representative talks in parliament on our behalf, to participatory democracy, where our voices go straight into parliament. Parliament listens to us as well. And this is amply evident because if you look at records, major laws are not debated in parliament. Even in the last 7-8 years, major laws have not been debated in parliament. They have not gone to select committees and standing committees. Things have been put in through ordinance or through select groups of people deciding on issues. And these things cannot work. And I don't need to go into details. There are so many things that have happened like this. The money bill, for instance, and also the financing of political parties for another, where all these issues must and should be debated with people in a democracy, have all been done without any consultation with any of us. So in 2004, it looked as if Indian democracy was turning an important point, and the whole branding of people as specialists, as technocrats, and people who are qualified, and then the others as unqualified people who are just users, just use the tools of implementing a public program. All this stood on its head, so much so that we actually were made to break through this and say that participatory democracy is from practice to theory. It's not from theory to practice. And when you go from theory to practice, you make the best possible laws, because you know that the practice will work. Then the theory then gives the structure and the authority for that particular practice to be transformed and taken to a much larger horizon and a much larger structure, so that many more people benefit from it. And that's how both the right to information law and the MGNREGA were actually done. Through practice, we showed them through practice of public works, we showed them through practice of how information is accessed, we showed them through practice of how corrupt practices are corroding into the system. So agitations for new policies and laws and policies, they did not actually deliver themselves. If they have not delivered themselves today to the degree which they should have, is because of lack of monitoring and lack of public support within the bureaucracy. So that's why we are now demanding a right to accountability law, where anyone who does not deliver after it is proven that there's something wrong or an order is not implemented, that person should be prosecuted. Anyway, so much so that the two laws became so much of a novelty that Stiglitz, who's a winner of the Nobel Prize for Economics, came to India and said that the MGNREGA is one of the best laws passed in the world to look at economic inequality in terms of employment and in terms of understanding how to work a democracy. He made this statement. People all over the world have been interested in these two laws only because they could not understand how people who did not have degrees, who did not have literacy, could conceive of a law which was so completely all-encompassing and gave power to so many different kinds of categories. So participatory budget and participation in lawmaking has become a kind of culture that MKSS has brought into with many other organizations into the Indian polity. If you look at the spate of other laws that were passed in that period by the NAC, it includes right to forest rights, it includes domestic workers' rights, it includes right to education, it includes many other rights. So the rights-based laws became the mode through which the directive principles of state policy could be actually transferred to people, because as you all know, the directive principles of state policy is not justiciable. So what more do we take? So we looked at the fundamental rights, and each fundamental right, like right to information, originates from Article 19 of the Indian Constitution. So the right to information and all these are from fundamental rights, so that they cannot be questioned, and they are laws, because no succeeding government can set aside this because it's inconvenient to them. It can only be done by Parliament. But along with this, we have worked with participatory budget and current work in Rajasthan, and my colleague Nikhil Dey has joined, I think, and I'm going to transfer this to him and ask him to talk about what has happened since in Rajasthan and what are the current engagements we have, and how, because the Rajasthan government has accepted the notion of a common platform for discussion, the tradition of engaging with government, of public policy with a lot of adversarial comment. It's not as if we get co-opted. Every day there are arguments. Over every clause there are arguments. About every issue there is an argument. But on the other hand, there are people involved, and there are meetings with people in the villages of India. In Rajasthan, they come together in districts, they come together in the state, and we have a campaign called the Suchna Rozgar Abhiyan, which has got 150 organizations all over Rajasthan, which come together periodically to debate and discuss about what laws we want, what form the law should take, and exactly what, in fact, the clauses of the new laws should be. So I'll introduce Nikhil Dey because he has not been introduced. Nikhil has a degree in law. He also studied partly in the United States. He joined with me and Shankar in the MKSS when he was 21. He has since been working with us, and he has been instrumental in giving the legal contribution to, and much more than that, mobilizing and getting everything together to form all these laws. But particularly, he has been instrumental in helping out with both the RTI and the MGNREGA laws, and with Jean Reyes with the MGNREGA and with others in the RTI law. And he has subsequently also been important in influencing the access of poor people to both a share of economic power, social power, and access to government functioning, so that we can have control over government functioning in Rajasthan and India. I'm going to hand over to Nikhil. Nikhil is there, I think. And we are both colleagues of the same vintage, because I may be older than Nikhil, but so far as MKSS is concerned, we are both co-founder members of MKSS. So I request Nikhil to please take over from here. You'll all forgive me, but you will find him a much better speaker and much more matter to give you. But I'm afraid my hospital condition is making it somewhat awkward for me. So if you'll all allow me, I'll just go off the screen and Nikhil will take over. And thank you very much for having me. And sorry for this this glitch.
We appreciate your comment.
Aruna, before you go, Professor Patel, I think you're the one who I'm interacting with. Forgive me if some names go wrong because we haven't met face to face. Aruna, I would like to do a little bit of a Q&A at the end of this. Professor Patel, if that's also possible. Is that something you will participate in as well, or do I take this from now till the end, Aruna?
Yeah.
I think, you assume that I will not be there.
Yeah.
But
Okay.
if I can, and I will join. So let's leave it.
Okay.
Can we leave it sort of open-ended?
Yeah.
Okay,
Yeah, and
that's it.
Professor Patel,
Yeah.
can we, am I addressing you right?
Yes. Yeah.
Yeah. So can we have about half an hour for question and
Yeah,
answers?
Yes.
We end at 1 o'clock, right? So
Yes,
I'll take
yeah.
the next half an hour. We are now at 12, roughly.
You
So
end at 12:30, and then you
Yeah.
have this, because after
Fine.
that, the Professor
Vibhuti.
Albertina. Yeah.
Sorry, is that Vibhuti I'm speaking to?
Yes. Yeah. You had been to Bombay.
Oh,
and everything.
I'm so sorry, Vibhuti.
Yeah.
I simply did not place you. My absolute
Yeah.
apologies. Please
Yeah.
forgive me.
Yeah.
And my mind state is also such that I'm not.
I understand. Yeah, we met at Kalina campus when you came to speak on RTI bill.
No, we have met, of course.
Several
So I'm
times. Several
sorry.
times in the meetings.
All right. Okay.
Thank you.
Right.
Yeah, please. Thanks a lot.
So shall I begin?
Go ahead. Yes, Mr.
Yeah. So there is a presentation which I'll bring later. First, I'd like to speak without the presentation. Can you hear me fine? Yeah.
Yes,
And
sir, we can.
firstly, I'm not a doctor in any form, either medical or with sufficient years of academic study. I'm just Nikhil. And I would just like to say that it is a very interesting topic we have in terms of social security, law and policy. And Aruna has covered a major portion where national law and policy was fundamentally affected for the first time in 2005 by people's participation in law and policy and by social movements participation. She spoke about the National Advisory Council and that period, but preceding that, years of social movements trying to make sure that their voices could get heard within law and policy. She mentioned the example of where we picked up on earlier law, for instance, the Maharashtra Employment Guarantee Scheme, but it was not just us. I want to make clear at the beginning that this is part of a large body of thousands of social movement organizations who started to come together on certain issues. RTI, for instance, affects every single social movement. It, in fact, affects every single citizen in India. And these two, the combination of two, if we look at RTI and NREGA together, one looks at the economic and social rights and the other looks at political rights. And the combination brings us to economic, social, and political rights within the framework of welfare, within the framework of rights, within the framework of citizens' participation in law and policy making, and citizens' participation in implementation. So when you look at RTI, I mean, essentially what we have learned is from people. The slogans they came up with initially was "Hamara paisa, hamara hisab, hum janenge, hum jiyenge." If you look at those conceptually, they are fabulous conceptions of both every citizen's right to ask questions, demand answers, and assert what they want done with their money, and have accounts and accountability. And hum janenge, hum jiyenge is our most marginalized citizen saying, without information, we cannot live. Without knowing about our rations, we don't get our rations. Without knowing our wages, which is where the RTI came from in the early 90s in Rajasthan, we won't get our wages. Without knowing what is happening on land acquisition, we will lose our land. So it is on every, or without knowing the FRA provisions, we will not be able to live in places where generations have lived, but FRA gave a protection. So it's a connection with every movement. And NREJ gave us an idea for the first time in the world, actually, that economic rights, something as ambitious as employment and the right to work, it's just a small step towards the right to work, could be legislated by a country the size of India with its challenges the way that they were. And at a time when around the world, neoliberal globalization was saying, leave everything to the market, the state can't do anything. What I do want to, so the first most important point I want to make is that this entire social movement's rights-based legislation actually draws its inspiration from a part of the Constitution which has been forgotten in policymaking, which is the directive principles of state policy. Aruna mentioned some of the articles from there, but if you look today at policy, the only thing that's looked at in policy is growth rates. Who gets the benefit of that growth? We don't get concerned. How it comes, we don't get concerned. And we have lost our constitutional mandate that whatever we are doing, if you look at the entire constitution or directive principles, growth is not mentioned. Of course, we want growth. Without growth, we cannot have society progressing. But what kind of growth? Growth for whose benefit? Growth that goes where? That we are directed by Part 4 of our Constitution, the directive principles of state policy, which say this is the direction you want greater equity. This is the direction where you want the right to work. This is the direction where you want a fair wage. This is the direction where you want the right to health. This is the direction where you want economic and social security, where you want equality between communities. And that's the great, tremendous, fabulous challenge, creative challenge that India has been, with all our various communities, with all the poverty when independence came along, with the fight for independence that incorporated all this. So I want to say that even social movements have drawn their inspiration from that part. And today, if you look at evaluations pre and post budget, very few make references to the directive principles of state policy, whereas that's where we should be directed by and from. And that's where our economic parties' political manifesto should fall within the framework of that, because that's what it's saying. It's not that like it's a fundamental right. It is aspirational, but after all, what are our manifestos? It's an aspiration of what we should be. So I want to make that very strong point at the beginning. Second point I want to make is that in the midst of neoliberal globalization, lots of problems are happening. So even in great celebration of India post-1991, economic liberalization, suddenly you realize that huge numbers of people were not actually either shining or part of the development thing or were benefiting as much. And trickle down, as Aruna mentioned, was not working. Trickle down was a theory that was imposed upon all of us. And we live amongst poor people, millions of them. So we saw. And then there were, of course, great doubts raised by many economists, and the pink papers, as we say, were full of doubts. Narega, you may as well throw money from helicopters. Narega is throwing money down the drain. And we saw as soon as Narega came on the economic side that there were, when you had the first economic downturn globally, India did not suffer like that. Why? Because Narega was there. Countries and parts of the countries that had no market activity were functioning. Why? Because Narega money was going straight into those markets. that there was a framework for delivery that came right across the country that incorporated all these modern things about DBT. Narega, for instance, far before DBT was talked about, was the first one to say money will go through pensions and or through post offices and bank accounts. So Narega provided a platform of modern economic delivery of state responsibilities. And it was the first amongst those rights-based laws, but we followed with 8 or 10 of them in this. I'm going to first talk about, and then next part of my presentation is going to look at Rajasthan today. So Narega looked at actually, so if you look at the different range of rights-based laws that came in, it was RTI, it was Narega, it was the Forest Rights Act, which provided Adivasis who were living in forest areas their right for the first time to live there. Otherwise, they were being thrown out by others who were claiming that they had no papers and no rights to live there. And they were the ones who had saved forests. Then there was the Street Vendors Act. All of us know how much we benefit from street vendors, how much we benefited in COVID as well, while they were taking their risk. And yet they have no protection. They're thrown out and now edged out by malls. There was the social security legislation, very poor, no money in it, but it started to show which direction you want to go to. There was the amendments to the Disabilities Act, which was almost like a new act altogether. Phenomenal in what it gave actually to the disability community in a rights-based framework. There was the amendments to the SC/ST Atrocities Act, which again gave very strong ideas of exactly how it would take place. There were amendments to the Land Acquisition Act. These are 3 sets of amendments, but they were comprehensive amendments. Land Acquisition Act was in British time scenario, and here it gave rights to the farmers actually, and it changed the whole. Not even now there are many battles, but at least it gave farmers and small landowners everywhere the right to decide. The idea of prior informed consent began to come in. So this combination of economic, political, and social rights at the level. How do you live if your land is going to be taken over because of some industrial concern being more important or a corporate concern being more important? And these are questions that we are facing day in and day out. There was the domestic violence. I don't know, phones operating from my phones, but my voice may go for a second or two. So there was the Domestic Violence Act. There was the entire framework actually on which started to get debated but did not come in fully, of domestic workers. All of us who speak English actually know how much of our homes are totally supported by domestic workers. And just to give you and domestic workers has not yet come. There was the Right to Education Act, which is if you compare it with Narega, it did not have as much accountability as we should have had. There was the Whistleblower Protection Act that got passed, but which has not yet been notified. So I'm just giving you the range. Some dealt with democracy, some dealt with the poorest people in rural areas, some with urban areas, some with forest areas, some with people who are street vendors in urban areas, and some did not come. Where do I place this now before I give you the next part of my presentation? The UPA 1 and UPA 2. UPA 1 was a much stronger set of legislations. UPA 2 had many more legislations, but much weaker. And I say that because I've been involved in the drafting of many of these legislations, and the weakness comes from how accountable you make both the structure and system for delivering what they promise.
And then there is on reservations on fetish on the side.
So
yeah,
I think it's a little bit of, if someone, yeah.
No,
Yeah, so there was that. And then you had an election that was shown as saying that all this is actually a dole and you want to close this down and you want to empower people through the market once again. And so there was a comprehensive attack on the rights-based legislations from that period. And I'm speaking completely theoretically and practically on the policies. All policies are connected with politics, but these are politics that are also going on. And so you had a reduction in NREG expenditure, even in UPA 2, and then in NDA to when from the years of 2014. You had on Narega the Prime Minister saying that this is just digging ditches and it's not worth it. You not being able to actually do what you had to and you needed to do. And as a result of that, you had this debate once again coming up of these rights being just doles, which has now become a debate of two terms. If you look at Revdi in Hindi and freebies in English. Revdi came from the Prime Minister again saying, are we distributing Revdis? And what is a Revdi didn't get defined. And freebies came from the Supreme Court even taking up a PIL and saying, what is a freebie? Or attention for the particular reason because the Revdis and freebies are on our side. What is it? It is Revdi versus Haq and it is freebies versus rights. It is our belief that the directive principles of state policy sought to give us all basic rights in the economic sphere, in the political sphere, in the social sphere, which Dr. Ambedkar had so eloquently described as that's the challenge. We felt that the directive principles were things we were fighting for, and we kept fighting for it as we went along. And many of them, if you look at the right to education is towards the directive principles, NREG is towards the directive principles. Now I'll give you some of the shortcomings. There was no right to health. And we hit COVID without a right to health law. And you saw what happened with COVID. It was mayhem. And in fact, for the first time, we had affluent people who used to write very critical things about these rights-based things, saying everything should be left to the market, saying, where is the state? What is it doing? Why are the hospitals in this shape? Only the state can deliver. In cities like Delhi, many of you may be in from urban big centers, you know what happened during COVID when there was lack of oxygen, when there was lack of a basic framework to deal with equal health for all. And when you had private sector supposed to get access, but actually not really giving access to health to everyone. So it's in this framework that I'm going to show you the next presentation and our battle in Rajasthan, battle with a government that has actually been very responsive. And we must admit that it's been responsible. Many of you will know that the right to health law was passed recently in Rajasthan. Many of you will know there was a lot of private sector opposition to that law. Why? Because the law actually deals only with the state sector. It's only in emergency care that it deals with the private sector. And yet using that emergency care clause, the private sector was against it because we believe today, and this I speak not just from the private sector, but also from the point of view of NGOs, the privatization of basic delivery of government services, be it health, be it education, be it Anganwadis, be it nutrition, be it any of those things, is phenomenally harmful to what we need to deliver as a state. In our opinion, if the state can't deliver these things, it has no business to be there. That government has no business to be there. So that's a strong point of view that we are putting across. And that's why in the right to health law, we were very, not just puzzled, but we were concerned that a law that 95% deals with the state, saying everything will be free, everything will be equal, the state institutions will deliver, was argued against by the private sector for that 5% that you cannot argue about. That when someone is facing a life and death crisis, they should be able to walk into an institution without having to pay any money and be treated until they can be put into an institution where financial arrangements can be made for them. Even after the state in that particular case said, the government said that we will underwrite whatever costs you had for that period. Even then there was so much opposition. So I've given this as an example because I assume many of you will know about the right to health and what happened in that. But in my opinion, the reason I think it's very important to place this in front of you is because we have a scenario of many other things that I'm now going to talk about in the next 10 minutes and then open it up. In Rajasthan, that's happening. And I hope that this idea of the Rajasthan model of comprehensive social security, which is what we are talking about, social security law and policy, will give you that greater idea within law and policy, and we can talk about it because it's happening just now. So if we can share, do screen sharing, please, of what I sent you. It's in Hindi, but I will speak of it in English. I will do it very quickly. To give you a background to this, this is an official, at the end of a period when we sat one whole day on post-budget consultation in Rajasthan. 2,000 people came together, where the chief minister came for the last 2 hours. Post-budget. Pre-budget, we had a number of consultations of what should go in. But very often, there are pre-budget consultations in many places, including the central government, but there are very few post-budget, to mean that what you have announced in the budget, how will you hold to it? What kind of accountability do you have over that? So I will keep saying next, and if you could. So this happened at the Bidla Auditorium. This happened last year. There was a similar one this year, but I'm just showing you last year to show you that what's happening is not just election. Please have the next slide. Someone who is handling, someone who's handling it, please. I don't know how to do this.
Nikita, yeah.
Yeah, Nikita, if you could kindly put the next slide.
Nikita, bottom, yeah, that.
Right. So you can see what we are doing here is part of a process where we've said, and civil society is looking at each one of the budget announcements and making particular suggestions. Now, what is the range of budget announcements related to what we see as the social sector? You will see, and then I'll come to this here. Next slide, please. So some were generic demands. Now you can see on Mahatma Gandhi Narega, I'll be very quick because I have less time and I want to have a discussion. So on Mahatma Gandhi Narega, there was a question of giving 25 days extra employment. That was the announcement that was put into place. That this year is going to be part of a law. This was just part of a scheme. Let's go to the next slide. Urban employment guarantee, Rajasthan had the largest. There's been a big debate about this since COVID. Rajasthan had the largest one with 800 crores allocated last year. And this is about how to run that scheme because it was being run for the first time. This year, it is going to be part of a law, the first urban employment guarantee law in the country. Next slide, please. Homeless policy. For homeless, it's a smaller number of people, but a very, very vulnerable set of people, very old policies, concerns lots of people. So there's a new homeless policy, which is this year being implemented. Last year was being made and money was allocated for that. Next slide, please. On education, post-COVID, how do you get back to education? What do you do in terms of hostels? What do you do in terms of places? What do you do? And it'll come to in the next slide, even what do you do in terms of child labor increasing after COVID? This had a very big thing. We won't go into the details. Next slide, please. Next slide is a new policy on child labor. Again, education and child labor have an intrinsic connection. If a child is not in school, the child will be working. If the child is working, the child won't be in school. How do you deal with it? And particular parts of the state that were very vulnerable, and huge numbers of girls and others who went out of schools and into the workforce, which was a tragedy all across the country. Next slide, please. Right to health. It was a budget announcement. It was an announcement in the Congress manifesto. We kept after them for that. And this year there's a law that's been passed, which I mentioned, spent a lot of time on. But here we were dealing with how we wanted it to come. That's next slide. Concentrating on preventive care, and within health is another thing which is called the Chiranjeevi Yojana, which is one of the largest insurance schemes in the state. A lot of us have questions about that. It's separate from the right to health law, where it says hospitalization. Last year it was 10 lakhs. Now it's become 25 lakhs hospitalization insurance, and it is universal to the extent that the state government pays the insurance premium for 80% people. 25 lakhs per family. And for the rest, if you pay 850, I pay 850 rupees once a year. And though your entire family is covered, no matter how rich or poor you are, if you want to opt in. So it's a near universal hospitalization insurance. Next slide, please. SCP, TSP, this is a extremely important for policymakers way to deal with the scheduled caste, scheduled tribe community, that according to their population should be the expenditure on them. This has been put into law. There was already a law in Karnataka, there was a law in Andhra, there was a law in Telangana. We brought the law in Rajasthan with a special untied fund for both communities to be able to decide how they can show what kind of work can happen so that the development of their poorest. So it's like a reservation of money, not of jobs. Next slide, please. Forest Rights Act. Of course, the act is already there. The rules had come in. There had been huge amount of work, mainly on individual entitlements. But the heart of the Forest Rights Act is community forest rights. Very little had been done in Rajasthan. So the budget announcement was that every single village in forest areas will have a community forest rights project allocated, and that had to be run in a campaign mode. Next slide, please. So some 6,000 villages or maybe more. Building and other construction workers is all of those. There's again a law, but to make that law meaningful and to make its entire provisions meaningful, and there was huge ghapla in it, huge corruption. How do you make it more transparent and accountable? On that, we had been doing many social audits and things. So this had to do with our demands on implementation. Next slide, please. And they said in 3 months, we will pay. That was a budget announcement, pay all outstanding. Silicosis, I don't know how many of you are familiar. It's something I got familiar with 20 years after working in Rajasthan. It is a blood money disease in the sense that those who are mine workers and those who work with stones, we have them in our homes. Those who have mining concerns mint money. And these are people who are dying in their 20s and 30s. There are some 25,000 silicosis people now, and most of them are dying in 2 or 3 years. You can imagine the kind of phenomenal pain that's caused in that. There's a new policy, but the implementation of it, and Rajasthan has the most progressive policy on silicosis. Next slide, please. Food security, who should be covered and not covered, who is not covered actually today, how do you cover them? There are today, even though there's this big debate, all of you know, and also know the PM program, which was there during COVID, which gave 5 kilos extra to 81 crore people. That was stopped. But the state government also had promised of adding people. It's added some, but not added enough. And there's a massive debate related to, and this is where policy makes such a difference. For instance, the increase in population. We are going by the 2011 census. So anyone born into a family who's a national food security beneficiary, that child does not get the benefit of it. It is as bad as that. And so how do we press the state government to do what it can on that? And it's going on even now. Next slide, please. Women's empowerment, there's a whole bunch of different things, because here it's not a question of money, but it centered around a new women's policy and what should go into that policy, because that affects the whole framework. And this is why, again, constitution, law, policy, rules, guidelines, this kind of hierarchy does make a difference, because a policy affects all the schemes within women's empowerment. Next slide, please. Ghumantu, Ardh Ghumantu, Vimukt, there's a new policy for DNT. It wasn't there. Last year it was announced. This year we've been in the midst of many of those discussions for denotified tribes, as well as for nomadic communities and semi-nomadic communities. They are the most marginalized today in many ways. They become our rag pickers, they become our homeless people. And so policy on that, and the discussions are going on. If any of you are interested, please do plug in. The policy is about to be announced, and people like Professor Ganesh Devi, people like Renke, who used to be the chair of the denotified tribes community, of the commission, all of them have been involved in it, and the new policy is coming into effect. Next slide, please. Next slide is Lok Kalakar. There is India's first scheme. Rajasthan has a huge number of Lok Kalakars. They live in penury, except a few of them who have fat passports, having traveled to 50 countries. Even their homes are not so well off. They represent Rajasthan. When people see Rajasthan's color, they see their songs, they see their dancing. That's what I mean, draws people to Rajasthan, but their own situation is very bad. And their kala is also dying as a result, moving from feudalism to capitalist market. So there is a new announcement of a 100-day guarantee, employment guarantee to lok kalakars, which came during COVID. It started getting formulated and it's now being rolled out. And the big meeting to roll it out is on the 13th of July. If any of you can come, we would welcome you to come, because you have to see these things to believe it, how much of a difference it makes. So far, there's only been some 20,000 people's registration, but we believe there are about 100,000 such people. They will get 500 rupees a day for doing their kala in schools, in panchayats, in other places, and 100 days guaranteed employment in a year. Next slide, please. Palanhar is a phenomenal scheme in Rajasthan for orphans and children of widows to go to school. It's a conditional cash transfer if they go to school, and they get, orphans get 2,500 a month. Children of widows get 1,000 rupees a month. So many widows are surviving because of that, and their kids are going to school and really coming out much better. A study needs to be done on how great this is. And that amount has just been increased from 1,000 to 1,500 and 750 to 1,000 for kids who are under 5. So let's go, next slide, please. Transparency and accountability. The one thing on which there have been 3 budget announcements, an announcement of the Congress party. We are in massive battle. Everywhere we are winning, but on Jawabdehi, we are unable to make that breakthrough because the bureaucracy is so strongly against us. Even in the central government, we brought it to parliament. There was a consensus amongst parties, but the grievance redress law did not get passed. This is not Lokpal. Lokpal is very necessary, but this is of accountability at the lowest level. If I don't get my rations, if I don't get my kid into school, if I don't get my pension, if I don't get that, what do I do? So let's end this. I think that's the last slide, just see. That ends it. No, Yuva Niti, a youth policy, new youth policy, and there's going to be now 50,000 libraries and Samvidhan Kendras running by youth to be able to do youth activities as well as other activities. I won't go into that. Next slide, please. Jail and police, again, next slide. I'm just now don't have time. Road security, and actually how we need to look at a public transport policy that we are working on. We don't have now yet, but we are working on. Next slide. In farmers, there's a whole bunch of stuff on Krishi Kalyan. They've given free electricity to up to 2,000 units to farmers. This may be a very debatable thing, but it is one of those things that's being talked about. But if we see the crisis in the agriculture, how much we need to do for farmers, right? Is that the end? Oh. This is the MGISS. This is the one that's running the libraries and Samvidhan Kendras to see that we need So can you hear me?
Yes.
Can you hear? Yeah,
Yes.
okay. Sorry, my apologies. That was a very important call that I had.
No.
So this, I think, finishes it. Just see the next slide. This is to look at. This is a Shanti and Sadbhav. I've just mentioned it. Those are connected. Next slide. Okay. So this gives you, I may tell you, may give you an idea actually that this year, just to give you one law, there is a minimum income guarantee law. And if you compare it, for instance, the 5 guarantees that were given in Karnataka that they said we won them the elections, one of that is that to give minimum income to every woman head of every household head, to the woman head of every household. Now there, how do you choose? Do you give it universally? Do you give it to some? As soon as you start having BPL, you have a problem. So Rajasthan's alternative, which is now going to get legislated next month, is a minimum income guarantee that says 125 days in Narega, we are demanding 200. So 25 days extra from the state by law, not by scheme. 125 days in urban areas by law, not by scheme. And finally, who exactly will get, those who cannot work, what will they get? And the first pension, social security pension law in the country. So the social security pension law says that you will get 1,000 rupees minimum pension by law with a 15% increase every year. Just to give you a contrast, so far social security pensions have been from the central government. They are 200 rupees a month, 200 rupees a month. And the rest, those states that give will give. And actually it says there should be a matching amount. So even if you were to get 400, what would that mean? And there are 1 crore social security pensioners in Rajasthan, elderly, disabled, single women, and then a lot of chota categories, including people who are serving a life sentence in jail, or people who are transgenders, or those who cannot earn. Just that one law I want to end with. That will get legislated. The draft has been made. It's going to come. It will be the first pension law of the country, the first urban employment guarantee law of the country. It will build on earlier legislation. It will work towards our idea of what a welfare state is. And to my mind, it's a better formulation than just giving 2,000 rupees to each family, because the selection of that is a massive battle, whereas here it's self-selection. Those who are willing to work at minimum wages or 125, 150 or 200 days can work. Thanks. We can have questions. My apologies for going over, but I did want to give you an idea of the range of things that are happening. And they are happening because of a push. Of course, civil society can't legislate. We are not in assemblies or in parliament, but we are today partners in this, sometimes through adversarial action, sometimes through working together on laws, rules, guidelines, sometimes on implementing together, which is actually all a solid engagement. Thank you.
Thank you, sir, for such an enlightening and insightful session. Now I request Professor Vibhuti Patel to share her remarks. Ma'am, please unmute yourself.
Both Dr. Aruna Roy and Mr. Nikhil Dey, both of you gave a very, very inspiring account of your work, because people think that in these difficult times, nothing is possible. That is the kind of depression which you see even among the most of the activists in social movement. But your experience shows that if we are with the people, we can do quite a lot. My main question is that about this whole universalization versus targeted support. If countries poorer than us, like Thailand, can have universalization of health, why can't we approach, or Kerala? So many things are universalized in the state of Kerala. So can we work towards universalization rather than targeted intervention by the state? And second one is that what are the efforts made to remove Aadhaar-linked relief and support by the state? Thank you.
Yeah, so universalization, I am completely in favor of. Not because I think the rich in the village should get whatever they get, which they do get, but because I think the rich enter the targeted group and push out others. I also think if more affluent and middle class people do take benefit, let's say, of something like food security or Narega, khana hi to mil raha hai. What is the big deal? Or you're getting health. So England, UK's health system gives it to anyone. And in India, you can say, if you want that, you come. Rajasthan's done both. It's done privatization as well as this. But there also, they've done universalization of privatization. So as I mentioned, so some people can pay $850 a year, which is nothing, to get that same 25 lakh coverage. I have questions about privatization and private delivery, but I won't get into that. So I completely agree with you. And that's why Rajasthan's things, most of them are universalization or moving towards it. And that's why I gave the example of the minimum income, because it's the most outstanding example. Today, it's not, even though BJP has talked about Revdi, that income has also gone in Madhya Pradesh, where they have a BJP government. It's also going in Karnataka, where there's a Congress government. So this is a trend all over. To our mind, when you are saying through employment, you will get it. It does self-selection. It is universal rights, but you choose. Only those who are not getting wages elsewhere will go to that. And it gives everyone, all citizens, a sense of within that a right that they can do it. But most importantly, it actually allows at least the poorest access. It is a structure by which. And since your second question also refers to access, which is a very important one, Aadhaar, I think many of your listeners would be both actually aware of this, would be similar with your views and my views on this, but also many of us find this entire tidal wave of saying DBT and Aadhaar. Rajasthan has a family card called Jan Aadhaar. That is the only way to deliver. I feel, yes, it is something. If you say that this was so great and you should make it not mandatory but voluntary, then I don't have a battle with it. But when you say you will make it mandatory, that today the Aadhaar-based payment system, what you talked about, has been applied. We are listening to Narega, but it's also being applied to pensions and across the board, PM Kisan everywhere, which not only says you must have an Aadhaar, it says you must link the Aadhaar to that entitlement card like a job card. And finally, it says that DBT payment will be made through being on the NPCI tracker, on the NPCI mapper, which is almost impossible to do because you need all kinds of KYCs to do it. And there are 20, 30, 50% people who are not being able to be on it. And you're saying you will not make payments, which is illegal, unconstitutional, not allowed even under Aadhaar because you all have an Aadhaar. Today, the Aadhaar authority is saying that, yeah, we have 100% coverage, not 99, 100% coverage. Then if you have coverage, after that, you're adding layers and layers and layers into this, where you are making sure that payment, half the people won't get or 20%. Let me give you an example from Narega, from pensions in Rajasthan. 1 crore people get pensions. 2% of the pensions bounce from bank accounts for various reasons. Number doesn't match, Aadhaar, Jan Aadhaar mismatch, all kinds of things. 2% is 2 lakh pension families. Are we willing to put their life on the line? Is that not our responsibility to deliver to them? How can we make things mandatory that payments will be made only this way and no other way? Why are we not accountable for that? 2 lakhs people not getting their pensions. So it is ridiculous to have that. It is, and I don't have words that I was one of amongst the people who went against Aadhaar to the Supreme Court, mandatory Aadhaar. Aruna and I were both petitioners, not on the basis of surveillance and others, which are very important. Those are questions that need to be looked at. We went on the basis of what you claim you're making greater delivery and including you're actually excluding. But people don't listen. I hope people who are in this course will not only listen, many of them may understand, but will become active, because we are branded as people who are extreme in our views or just shouting about it all the time. But we have tired of talking even to the Aadhaar authority, and they say, this is a glitch, let's work it out. This is a glitch, let's work it out. So the whole digital world cannot be full of glitches where lakhs of people suffer.
Yeah, I think the fight has to go on. Yeah.
And some of you have to join it.
Yes, we are.
You have a more powerful voice than we have.
No. We are also. We are sailing in the same boat. Yeah.
Thank you, sir. We have, I request Shalu ma'am to give her remarks as well.
Yeah, no, sure. It's very inspiring and very insightful kind of session, and we have to get to know about so many policies and laws. But just one question I have is that what are the challenges you have faced while making these laws and policies? Because if like since a lot of if you talk about women's movement, domestic violence act, you said, but a lot of challenges are coming even from Supreme Court and even from the government. What they are saying is all these laws are being misused. All these kind of things are coming up, and even for the Forest Act and other things, they have diluted, some kind of the rights we have got. They're just trying to dilute now. But Right to Information Act, you know very well how the changes have been made. So how to deal with such kind of challenges. How to counter these kind of of course we are representing data and everything. But what could be the other possible measures to really ensure that these the rights we have got through so much of struggle shouldn't be diluted, but it should be enforced in a very good manner.
So the only way out is, I would say, every single person who already agrees should make their voice stronger, especially those of us who are privileged, to make sure that these rights are not diluted. Those who have doubts about the rights We should talk. I mean, when I come here knowing I'm not talking to a set of people who are receivers of the rights. They, we know, are very, very powerfully, strongly coming out. And that's the only strength that saves those. Many of these laws are not easily implemented. A lot of what you talk about is both implementation and dilution, not just in the law, but dilution in implementation, which is why we want an accountability framework. So those who need it, those who have a vested interest in it, will make the effort, but they have very weak voices. Even if they are lax and cross, people rarely listen to them. If there wasn't the vote, they wouldn't listen at all. So even with all our issues about how representative the vote is, at least it gives an opportunity for these kinds of things. But the rest of us who are involved in the policy space, academics, government servants, bureaucrats, know a lot of these things. We also go into the details. We are at it all the time. And yes, there are challenges. We are also, when we do yatras, we've been beaten up. When we were fighting for RTI, but when you get the law in, then at least you're not fighting for the law where you're being beaten up and called anti-national and this and that. At least you're saying you're actually trying to fight to implement the law and implement the constitution. Even so, you face challenges. That's people like us. There's a space for us. There is space for people like all of you. And I think there is so much that all of you can do. When I just see a kind of a quick vision of different kinds of people who are in this space listening, my only appeal would be that, it is not that we can change the world. And I think these laws give us an opportunity to fight. Even with people we say, लामबंद होने का मौका देता है. इसके लिए हमें ये अधिकार मिला जरूरी नहीं है. उसके लिए लड़ने का मौका मिला है. कईयों को मिलता है, कईयों को नहीं मिलता है. And we always have to keep our eye on the most marginalized. There will be, as I'm saying, in pensions, if 98 lakhs are getting it and 2 lakhs are not getting it, 98 lakhs are important, but 2 lakhs are just as important, that they must get their pension. That's a policy framework we must work on. That's what welfare means, the most marginalized first, their voice first. That's when you go out of a vote framework. A vote framework will only care about 98 lakhs. It's up to us to care about the 2 lakhs. To fight for the 1 crore and to say, okay, 98 lakhs have got it, but now the 2 lakhs, what about their voice? Should not stop.
Thank you, sir. The floor is now open for questions from the audience.
And I would just like to say that I also have to leave at 1. So I'm sorry it's short time, but there are about 15 minutes. So if we could definitely wind up at 1, because I have some calls I have to make.
Would you like to ask? Can you unmute and ask? Charuji, are you there?
One of the politicians outside India told that if the people are not protesting, then they're giving, if people are not protesting, they're not saying anything against the law. They are giving their consent to the law. And we were talking about rights of protest yesterday, and this came up. And I feel like as a citizen, I don't really know how to raise my voice. And I'm against the Aadhaar card because of the surveillance reasons. But I don't know what to do about it. How can the people who don't have power, like policymakers or politicians or anyone, just the basic normal citizens, how can we contribute and raise our voice? How can we make our voices strong?
Yeah, it's a very good question, but so गरीब लोगों के साथ हम हमेशा कहते हैं, I'll translate in English also, कि या तो आपके पास पैसा है या आपके पास पहुंच है. गरीबों के पास दोनों ही नहीं है. तो गरीबों के पास केवल संख्या है. And I would say that to any common citizen who feels helpless, because if they had money and if they had influence, they would use it. And if they are using it and still not getting it, they have to turn to make sure that they can bring their engagement into the public space. It means getting out of your comfort zones. It means joining with others and building solidarities and alliances. And it means putting democracy and a constitutional democracy to work. It is in a sense an irony that your constitutional democracy is being undermined and you don't know how to raise your voice, but unless you use that to strengthen the framework of constitutional democracy, you can never raise your voice. So I think there's this Bharatiyar quote, the famous poet from South India, who says that I am starving and my right to eat is very important, but even more important than that is my right to say that I am starving, because otherwise nobody will know that I am starving and I will never get my rights. It's in a song, I'm paraphrasing badly perhaps, but it's a very important thing. That democracy is as important as anything else for development. And the only ones who have actually therefore fought for democracy are the poor. So some of us who, even Savitri, you, and I would say for myself, when we get out of our slightly privileged zone where we think if we just write something or send a message, things should happen, we should understand things are going to happen only after struggle, and we need to join that struggle. It will enrich us as well.
Okay, thank you. Thank you for your answer.
So I have a question regarding Mahatma Gandhi National Rural Employment Guarantee Act. So it is a fact that this scheme provides temporary employment against a sustainable one, a more sustainable one. And I believe that in long term, it may hamper economic growth as well. So I would just like to know what your thoughts on it as to how can it be made more comprehensive to include structural development in terms of skill development, so on and so forth.
Yeah, so there are about 7 issues in the 3-4 lines that you've said that I would like to have normally debated. I don't have time, but I'll pick on one line, that it may hamper development in the long run.
Yes.
Firstly, I'd like to take 2 steps back to take you into one area where I don't know whether in this policy framework, we really look at it comprehensively, which is climate change. We are all talking about a growth model, sustainable development, even skill development, on a completely unsustainable way of growth ahead. We are going to suffer, and we are not taking those consequences into mind. We want a lifestyle which is fancier and fancier, equaling the West or equaling even China. Tomorrow, you put India equal to a middle-class person in the West or the North, and India is finished. The globe is finished. All the things that we talk about, what we are doing to destroy the environment, an unsustainable way of life, all that is what we are aspiring for. So if we succeed, we fail. NREGA does what? If there is one program, not just in India, in the world, that has actually done carbon sink, that has done sustainable, and what you say, you think there are 2 points there, which most people say, that there are no assets, proper assets that are built. Actually, NREGA is littered across the board with small, rural, extremely important infrastructure. A road to a hamlet of 20 homes, which allows those homes to come to a hospital. Someone who's receiving delivery to come, NREGA built it. A small check dam in an area, NREGA built it. A little watershed in one area, NREGA built it. A little area, now they're finished. Those works are finished, but those works were all built in these 15 years of NREGA. If you look at tree cover, NREGA did it. Maybe not well enough. Again, that's a problem because we don't do accountability well enough. But that was done, and it was done with a ban on labor displacing machines. So therefore, machines did not build it, people built it. And it was done in a way that it was environmentally friendly, truly so. But we don't examine that. I won't go further, but I would just like to say that, of course, NREGA should have many more works, but not in that same thing that we think someone should be necessarily. It needs to be looking bottom up. Now we need to change the nature of works. We do need to bring skill development into it. Completely agreed. For instance, and I can talk for many hours and days, but NREGA is condemned without being properly studied. I want to know one study that says NREGA's works were all useless, one district, one block, one area. We've done social audits. A lot of useless stuff happens because of corruption. But the system doesn't take action on corruption. So, and we've been beaten up, we've done everything. We've done it so that Narega's weaknesses come out and it becomes stronger. So I think some of you should get involved. And of course, Narega needs more innovation, but Narega needs to give people work and for work and income in their home. That's a fundamental thing. Har haath ko kaam do, kaam ka pura daam do. That's a huge part of our development.
Oh, thank you, sir.
Okay, Dikshita ji has also raised hand. Kumari Dikshita, can you hear us?
Yes, sir.
Please.
So, basically, my question is regarding RTI. So, RTI, as we know about it, that it has empowered us to ask government like questions regarding policies or regarding other stuff, and it has empowered. It ensures the accountability from the side of government, but as I know, there is a kind of fear in the mind of people. Like what happens if we ask questions from the government? As we also know, there are multiple attacks on RTI activists, and the Whistleblower Act is is also not protecting people from attacks or the threats. So what we can do to resolve this issue? So, I can ask questions from the government, and at the same time, I'm not afraid to ask questions.
So there are three things I'd like to say. Number one is that despite more than 100 people being killed, there are still more than 80 lakh RTI applicants a year. So let's give them a kind of thank you, a hand. Each one of them are the RTI warriors. Why? Because they don't give up. They are the citizens who don't give up. But of course, they should not be killed. Of course, there should be action. And that's why the whistleblower law, which is not perfect, it will not sort out anything, but it will give some help. It's not been implemented yet. So why don't all of you, some of you who are concerned about this, make a campaign to say, notify the act, bring the rules into place, put it, at least it will save some lives. Every life that goes is, in my mind, on its blood on the hands of the government, because it's not putting this provision into place. Some courts have also done that. But I'll go into some things that I think will seem attractive to all of you, which is proactively, what can you do? Why don't you put information, all the information out in the public domain? We haven't had time today. In Rajasthan, through people's movements, the government has built a portal called Jan Suchna portal. The most progressive part of the RTI Act is Section 4, which again we have not talked about, which is mandatory proactive disclosure. Everything that government had, RTI made it available except for Section 8, but then they digitized it and hid it behind admin logins. So we've said remove admin logins and give Janta information system, people digitized information, all that the government has, except for that which is barred by Section 8. Today, that Jan Suchna portal, please all of you go to that URL, just write rajasthan.jansuchnaportal.gov.in, just write that and go and see it. More than 13, since 2019, more than 13 crore visitors are there on the counter just for information. And more than 20 crore bits of information have been downloaded. If you proactively, including mining information where people used to be killed, which is the mining lease, what are its coordinates, what is the latitude, longitude, how much is it paying in royalty? These were all bits of information RTI could not get, but now you get it proactively. Go and look at that if you have the time, and do join that also. That should be in every state and across the country. So there are some ways in which we move further and further and further towards more and more transparency, and greater accountability will require struggle, a battle. People will get attacked because there are such huge vested interests against it. So some of us will have to lose our fear, and some of us will have to give solidarity to those who have lost their fear, and some will have to be motivated en masse so that there is a shift and the government realizes we have to move from a culture of secrecy to a culture of transparency.
Thank you. Sir, I would like to ask a last question to you.
Yeah.
Adhering to the time. As an economist, I get a lot of questions, also Professor Patel, that those leaning to the right wing, they say that the right discourse is not great, or it's like it's not working because one, we don't have the budget. Second, it's not good, as Shweta was also saying, it's not in that prospect. How do we deal with that? With all the works
What do you mean by not good? Good or bad is like some telling a child you're not being good or bad. What do you mean by not
They're saying
good?
that it's not advisable. One should not do that.
I mean, why? Why? Not
No.
advisable because it's resulting in what? That's an important thing to tell me.
Yes, yes. So as per them, that's not a good expenditure or not a.
Yeah. So anyway, I'll end now with this. So I obviously all that I've said is completely against that. Obviously, all I've said is against, firstly, the mandate that we have, I go back to that, is the directive principles of state policy. So I think that should be argued against, and the system doesn't, the economists don't, the right wing doesn't. I don't know whether right wing governments are also passing these. So as I said, Madhya Pradesh is, during COVID, we did give it. If we did not have Narega and food security during COVID, we would have completely phenomenally lost lots of life right across the board. So I think there is no question. It's a very broad question, but I think all that I've said, you could agree, you could disagree, but I'm saying A, it has a legal mandate from the Constitution. B, we have seen it at work, and I've given examples of that. C, I don't think it can just be described in terms of Revdi or freebies, because it is not. It is the responsibility of the state to give some of these things like education, like health, also employment, also a standard of living, so also nutrition, so that children and our citizens can lead equal opportunity lives in the rest of their time. It's not their fault they were born into a poor home, nor should it be a privilege that someone is born into such a rich home, and such huge inequalities should persist. And finally, what you say about not being good, not advisable, not this, not that, I think requires a far more evidence-based discussion. And I am open to it on Narega, on food security, on other things, how much of a difference it has made. I can give anecdotes, I can give numbers. So it's not something that I'm saying in the world. So advisable or not, let's have an evidence-based discussion.
Great. Thank you. Thank you so much.
Thank you.
Shweta, over to you.
Thank you, Dr. Nikhil, and we also thank Professor Aruna Roy for taking out their time and providing us with such an insightful and enlightening session. Moving forward, we have Advocate Dr. Albertina Almeida, who will be taking the session on the topic Inclusion Laws and Policies 2. Advocate Dr. Albertina Almeida is a lawyer and human rights activist based in Goa. Welcome, ma'am, and over to you.
Hi. So on the last occasion, I had discussed with you the conceptual issues around reservations, around inclusionary policies. So this time we will run through the actual legal provisions and relate it back to the context in which those legal provisions have been enacted. So I will share a presentation. Is this visible?
Yeah, ma'am, you can go full screen also.
Just a minute, something is.
You can go in slideshow. Yeah.
Yeah, just a minute. Sorry. Oh. Sorry. Sorry, there's some problem.
Go ahead. Go ahead. Yeah.
Go ahead. Yes.
I'm just trying to. Okay. Oh. I'm just trying to expand this. So, sorry. Something, the problem.
It's okay, Albertina. Please go ahead. Yeah.
Yeah. The presentation is visible to you?
Yes.
Yeah. Sorry. So I'm just talking about the I am not going to go into the historical backdrop because we already discussed that last time. So I will begin by talking about the provisions. Now these provisions are applicable to the public sector. They're not applicable to the private sector yet, though there has been a demand that they should be applied to the private sector. So the constitutional mandate has there are various articles which provide this constitutional mandate for inclusion, specifically provide the constitutional mandate for inclusion. And those are Article 15, Article 16, Article 46, 330, and Article 335. I think sorry. Okay, so so I will look at.
Ma'am, are you changing slide because we are stuck on slide 1?
Yeah, I have changed the slide to Article 15. Are you not seeing it?
No.
Oh, Article. You are not seeing Article 15 as the caption?
No.
Oh.
Ma'am, you can stop share and then share again.
Slide is not moving. Yeah.
Oh, okay. Stop sharing. Okay.
Stop share. Yeah. And then again share.
Okay. So there's some.
Ma'am, don't go full screen. It will just be in working mode only, then it will work.
Okay, I'll just stop and do it again.
Yes, yes.
There is something in the settings today that it's sharing on the sides, so to say. Yeah. Do
Yes.
you see?
Yes, ma'am, don't go full screen.
Okay.
Just change from side. Yeah. Yes.
So as I was saying that the legal provisions, the constitutional provisions are not exact in terms of inclusion, are not exactly applicable to the public sector. Sorry, to the private sector. They're applicable to the public sector. There have been proposals to extend these provisions of reservation to the private sector as well. The Constitution mandates Articles 15, 16, there are these articles, that is Articles 15, 16, 46, 330, 335. I'll get into each of these articles. So Article 15 basically suggests that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So basically it says that you cannot discriminate. So then there were a lot of responses saying, if you cannot discriminate, how do you have reservations? Because that amounts to discrimination, because you are allowing, you are making special provisions for certain sections. That is where Article 15(2) comes in the picture, because it says that no citizen shall on grounds only of race, religion, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. The use of wells, tanks, bathing ghats, and places of public resort maintained wholly or partly by state funds or dedicated to the use of the general public. This is talking about discrimination. That is, you cannot discriminate against a citizen on the basis of, in terms of access to shops, public restaurants, etc., etc. Then Article 15 continues as follows. It says, nothing in this article shall prevent the state from making any special provisions for women and children. And then it says, this is a critical clause. Nothing in this article, in clause 2 of Article 29, shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens of the scheduled caste and the scheduled tribes. So what it means is you cannot discriminate, but you can make, which is different. It is not about discriminating. It is about making special provisions for women and children. So you can make special provisions for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. So nothing in this article or in subclause G of clause 1 shall prevent the state from making any special provisions for the advancement of any socially and educationally, or for the social or for the scheduled castes or the scheduled tribes, insofar as such special provisions relate to their admission to educational institutions, including, now here the private educational institutions have come into the picture, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30. So this is basically dealing with exceptions to Article 15, which says that there shall be no discrimination. Article 15 in continuation also has the provisions relating to economically weaker sections. I won't deal with that right away. As I told you, that amendment, the provisions for reservation for economically weaker sections were made more recently. And economic, who constitutes economically weaker sections would be on the criteria set by the state on the basis of family income and other indicators of economic disadvantage. Here, the issue is not of social or education or social disadvantage. Yeah. Now, as far as Article 16 is concerned, equality of opportunity in matters of public employment. It talks of this aspect of equality of opportunity. So the words are not just equality in employment, but equality of opportunity. That's a key word, equality of opportunity. So there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall, on grounds of so and on the same grounds, all these various grounds, be ineligible for or discriminated against in respect of any employment or office under the state. So there shall be no discrimination. So you can't say, for example, to a person from the scheduled caste or scheduled tribe that you are, you do not have, you are brainless, you are not meritorious, you have no right to these posts. So this is the first level, that there cannot be discriminated against. The second level is nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. Now here, this also covers, in a sense, this covers the scheduled castes and the scheduled tribes. And I'll give you the example because we're talking of residence. So for instance, there was a case in the local university, where in the Goa University, where there are reservations for scheduled castes and scheduled tribes there. So it's a state university. So the reservations go by the reservations made locally. Now, therefore, the point is that if somebody is declared as an ST in another state, this is not in relation to all India quotas. This is in relation to state level quotas. So if somebody is an ST in another state, that doesn't entitle that person to have the benefit of reservations of ST in a different state where he is not an ST. So that aspect we also need to remember. Now, nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution shall be a person professing a particular religion or belonging to a particular denomination. So this is another kind of reservation that was made. Now, I will move on to, so these are whatever I've spoken about, that is Article 15, 16, and of course the Article 14 that you all know, that Article 14 talks of equality and equal opportunity. And here we have had articles 15 and 16, which have kind of which have expanded on what is that notion of equality with reference to employment, with reference to non-discrimination, with reference to special provisions, and expanded on what equality of opportunity could look like as well. Now, from these are all fundamental rights. Beyond that, you have Article 46. That is, this comes under the ambit of directive principles. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. It says that the state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. Now, in view of all the current discussions as well, that a directive principle is not a direction, it's not like a mandatory for the state. What we need to also remember is that it is optional for the state to go ahead with a directive principle. But once it goes ahead with that directive principle, it cannot regress. It can only progress. So it cannot say, okay, now we will not provide for promotion of education and economic interests of SC, STs and will regress and, will not provide for it where it was already provided for. It can only progress in terms of these provisions. This is also in keeping with India's ratification of the International Covenant on Economic, Social and Cultural Rights, which, since it has ratified that, there it is very clear that when there can be no regression in terms of economic, social and cultural rights. So once you've reached a point, you can only go forward in terms of making more provisions, or you cannot regress on this point. Now, this is about reservations for scheduled castes and scheduled tribes, Article 330 in the Lok Sabha. So it says that the seat shall be reserved in the House of the People for the scheduled castes, the scheduled tribes, except the scheduled tribes in the autonomous districts of Assam and the scheduled tribes in the autonomous districts of Assam. So that's a separate kind of category. Now, the next thing is that the number of seats reserved in any state or union territory for the scheduled castes or scheduled tribes under clause 1 shall bear as nearly as may be the same proportion to the total number of seats allotted to the state or union territory in the House of the People as the population of the scheduled castes in the state or union territory, or of the scheduled tribes in the state or union territory, or part of the state or union territory. So basically, when we are talking of representation, the representation has to be in proportion to the number of seats. So if the state has a certain number of seats, and then, so let's say it has 10 seats, and scheduled castes constitute 2%. So let's say it has 100 seats. I'm just giving this for convenience now at this point for calculation. So if it has 100 seats, then at least 2 seats in Lok Sabha from that state have to be of scheduled castes and scheduled tribes. Now, the number of seats reserved in the House of the People for the scheduled tribes in the autonomous districts of Assam shall bear the total number of seats allotted to the state in proportion not less than the population of the scheduled tribes in the said autonomous district based to the tribal population of the state. Okay. So this is more to do with the exception with reference to the autonomous districts of Assam. Now, when we are talking of Article 335, this is a kind of a mixed provision. It can be read any which way. We are saying, we are talking about the provision is that the claims of the members of the scheduled caste and the scheduled tribes shall be taken into account consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or of a state. So, the point is that somewhere it brings in this point of efficiency of administration, and it kind of hints at that efficiency of administration, this whole debate of merit, it kind of hints negatively at the efficiency of the scheduled castes and the scheduled tribes. But it is a provision in the constitution, and one has to know that it is there in the constitution. Definition of scheduled castes. Now, because we are everywhere, we've talked of the words scheduled castes, scheduled tribes. Now, who are scheduled castes? So Article 341 goes into that. And it says the president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof by public notification, specify the castes, races or tribes or parts of a group or groups within caste, races of or tribes, which shall, for the purposes of this constitution, be deemed to be scheduled castes in relation to that state or union territory. Then it says that Parliament may by law include or exclude from the list of scheduled castes specified in a notification any race, caste or tribe or part of a group within any caste, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. So basically, what this provision is doing is saying how the process of how somebody may be specified to be a scheduled caste, race or tribe. And there has been again a process to evaluate the backwardness, the social backwardness by which certain communities have been declared as scheduled castes. Now it hinges a lot on the certificates issued in terms of that by the particular communities that this person belongs to the scheduled caste, which are already notified. Same now here, this is as far as definition of scheduled tribes. The same thing that they are notified by the president in consultation with the governor, where it is a state, to be deemed to be scheduled tribes in relation to that state or union territory, as the case may be. And they can by law include or exclude from the list any tribes, any particular tribes subsequently. Now the thing is that here, so you have both these articles in the constitution actually define the processes. Here in 366-24 again affirms that they go by article 341 in terms of who comes within the definition, can be considered a scheduled caste. So essentially a notification that these particular communities are scheduled castes, or that these particular communities are scheduled tribes, is a prerequisite for the representation. Now, what is the concept? It is about proportionate representation. So each time in terms of the census, the proportionate representation, the census is taken as the yardstick for deciding what is the proportion of scheduled castes in relation to the entire population, and what is the proportion of the scheduled tribes in relation to the entire population. And the reservations are made in proportion to the population of the respective categories. But of course, there is also there is the judgment which places a cap of 50%, which is the Indira Sawhney case. That is the landmark case that has set broadly the benchmarks for insofar as reservation is concerned. So it upheld a ceiling of 50% quotas, emphasized the concept of social backwardness, and it went with 11 indicators that the National Commission for Backward Classes had prescribed. But it also held the following, that reservations in public services, either by legislative or executive action, is neither a matter of policy nor a political issue. The higher courts in the country are constitutionally obliged to exercise the power of judicial review in every matter which is constitutional in nature or has potential of constitutional repercussions. So it is not something that that tomorrow the state can say, oh, listen, we don't now think of reservations anymore, because it has to go by the constitution, and it can at best judicially review the constitutional provisions. But it cannot go by the state government or the central government saying, oh, we've changed our policy, we are not now going to have reservations, or some political free-for-all between the various parties. It goes by a certain mandate which is there in the constitution, and if at all that mandate is to be challenged, it can be challenged through a process of judicial review. Now, the constitutional bar under Article 16(2) against state for not discriminating on race, religion is as much applicable to 16(4) as to Article 16(1), as they are part of the same scheme and serve the same constitutional purpose of ensuring equality. Identification of backward class by caste is against the constitutional mandate. The prohibition is not mitigated by using the word only in Article 16(2) as a cover and evolving certain socio-economic indicators and then applying it to caste in the identification, as the identification then suffers from the same vice. Such identification is apt to become arbitrary, as well as the indicators evolved and applied to the community may be equally applicable to other community which is excluded and the backward class of which is denied similar benefit. So the Indira Sawhney case kind of set out certain parameters for considering the reservations for scheduled castes and scheduled tribes. Now on to the definition of backward class. So this definition one finds in the Section 2 of the National Commission for Backward Classes Act. Backward classes means such backward classes of citizens other than scheduled castes and scheduled tribes. So once somebody is categorized as a scheduled caste and scheduled tribe, they cannot be categorized also as backward class. So they have to be, if they're not within scheduled castes and scheduled tribes, within the parameters on the basis of which these scheduled castes and scheduled tribes have been decided, then they come within the scope of backward tribes. They have to be notified by the central government. These lists are prepared. The central government has to prepare lists for providing reservation and appointment to the backward classes of citizens, which in its opinion are not adequately represented in services under the government of India and any local or other authority. The Ministry of Social Justice and Empowerment has notified the lists of castes / communities which are treated as other backward castes. So for instance, sometimes it will be communities, other backward classes, sorry. Sometimes it may be communities, sometimes it may be purely a caste classification. Now the criteria for, sorry, as far as the backward classes are concerned, the logic has been because the backwardness is not totally determined by the caste, caste sanctioned, so to say, the caste reinforced backwardness. So therefore, it was felt that it is possible for people to get. It is relatively easier for persons from this section to get out of that section, and they become a creamy layer. So therefore, and then very often what also happens is that those who become this creamy layer prevent others from that section of society, from that particular backward class, from reaping the benefits. So that is why there is a distinct mandate that the prevention of creamy layers from reservation entitlements will ensure a gradual percolation of reservation benefits to the more disadvantaged members of the reserved communities. So now, as far as scheduled caste is concerned, so the scheduled castes, the provision relating to scheduled, this is not there with reference to scheduled tribes, because you can also have scheduled Christian, scheduled tribes, but for example, or Muslim scheduled tribes. But when it comes to scheduled castes, no person professing a religion different from Hindu or Sikh or Buddhist religion can be deemed to be a member of a scheduled caste. Now, why possibly this provision was considered at that time was because the focus, there was a lot of thought to given to the fact that there is a religion sanctioned discrimination, and within the Hindu order there is a hierarchy, there is a caste, there is a sanction for caste. So therefore, there was a need to offset that religious sanction by these kinds of reservations, and to offset that discrimination based on that religious sanction. Now, the Sikh, as we know, the Sikh and Buddhist religions technically do not have caste, but the Sikh and Buddhist religions are, a lot of people, for example, have converted to the Buddhist religion because of the problems of caste. But that social backwardness does not stop, because people do trace your lineage back to what caste you belong to, and that is why possibly they said no person and limited it to Hindu, Sikh, or Buddhist religion to be considered as to be members of a scheduled caste. However, the fact is that casteism and caste system. So you will have, for example, a Christian, what is called Samar, that is the person who, a cobbler, you see, someone who deals with leather work. Now, this person, if he is a Christian, he's not entitled to reservations. So there has been a demand that he is not any less treated by the Catholic community, which does not have caste. There is no provision for caste within the religious scriptures or within the religious precepts of the Catholic community, and yet in practice, because of the cultural backgrounds, you have a caste system. So a cobbler or a barber will not be treated in the same way as people from other professions. You know, people who have been traditionally cobblers or barbers. But so therefore, there is a conscious demand that the other people from the other communities, other religious communities, who have been historically members of the scheduled castes, should be there should be reservations for this section of society. As I said, there is a bar of 15%. The time frame, so for political reservations, there was a time frame for 10 years, which has since been extended every 10 years. For education and employment, there is no time frame. But as I mentioned, even as far as political reservations, we generally know that to this date there are issues in terms of whether it's political, educational, or employment reservations. There are issues in terms of persisting casteism, persisting discrimination on the basis of ethnicity to this day, and therefore it's only fitting that the reservations have to be extended. Now, introduction of post-based reservations. Reservations till 1st July 1997 were computed on the basis of number of vacancies filled. Then, by the judgment in R.K. Sabharwal versus State of Punjab, the Supreme Court held that the reservations should be determined on the basis of number of posts in the cadre and not on the basis of vacancies. Accordingly, post-based reservations were introduced, and the basic principle of post-based reservations was that the number of posts filled by reservation by any category in a cadre should be equal to the quota prescribed for that category. Prior to introduction of post-based reservation, there was a provision of exchange of reservation between SCs and STs. After implementation of the post-based reservation, such exchange is no more possible. Also, the numbers, the proportions are different, and this has made the task of reservations much more clearer, and it helps it to be a lot more effective. Now, relaxation in the prescribed criteria. So another thing about legal provisions is, okay, you have reservations, but if you have reservations and then you say that somebody doesn't have merit, you see, then, or like doesn't have merit because they don't have a particular percentage, then that would amount to defeating the purpose of they don't have the same percentage as the percentages, the very high percentages maybe that there are for the general category who has to compete. Now here, this would effectively end up being discrimination for the scheduled castes and scheduled tribes, because the entire curriculum, first of all, is centered around frames of knowledge that are belonging to the upper castes. So, and apart from the historic backwardness, and given an opportunity, we know that, given an opportunity, any person can rise to the occasion. So therefore, there is a relaxation in the prescribed criteria for the posts in order to ensure that sufficient numbers of SCs and STs are available for the posts. There are separate interviews so that the judging does not take place in comparison with the upper caste candidates. Upper caste, I'm saying, because that's the terminology sometimes used, but we are, by this I'm referring to the dominant caste candidates. Now, sometimes there is a backlog. So what happens is the government has failed to implement, and then there are those posts were not reserved when they should have been reserved. So now, will that come within the 50%? No, it will come over and above the 50% because the government failed to fill up the post at the relevant time. It is treated as a backlog, and for that, those posts are announced separately. The backlog posts are usually announced separately. Now, in terms of electoral constituencies for the SCs and STs, they're usually those in which the proportion of their population is high. Now, coming to broadly what the jurisprudence has been, it's along the lines of the discussion we had in the previous lecture. The view expressed by Justice Subbarao was adopted by the Supreme Court in State of Kerala versus N.M. Thomas, which transformed the equality jurisprudence in India from that of formal equality to substantive equality. As I explained, you cannot have equality among unequals. So you have to have equitable provisions. You have to have special provisions. So that is what we are talking about when we are referring to substantive equality. Thus, this changed our understanding of reservations, special provisions of reservations. The courts held that special provisions they observed that the special provisions are a method to ameliorate the structural inequalities that exist in the society, without which true or factual equality will remain illusory. So often the question is, many people point at X or Y person from the scheduled caste and say, how does that person lack, in terms of forwardness? How does is that person lacking economically? It may be true in terms of a particular X individual, but if persons from scheduled castes are driven to kind of prove this at the stage of reservations, it would be difficult. Therefore, what was done is to recognize that there is a structural inequality. Even if some individual may be exceptionally have not borne the brunt of that backwardness or the conditions of that backwardness. That is why they say that the special provisions are a method to ameliorate the structural inequalities. Now, Justice, in this Indira Sawhney judgment, as I said, Justice B.P. Jivan Reddy, while delivering the majority judgment, observe that public employment gives a certain status and power besides the means of livelihood. So it is right to livelihood, we know, is guaranteed under Article 21 of the Constitution. But here, why are we talking of this in the context of public employment? Because apart from, it is about livelihood, but it is also about a certain status and power that comes from that particular employment. That is why I was talking about public employment in terms of the relatively higher posts, and we are not talking of public employment only, public employment in those categories where anyway there is a unsaid reservation because nobody else will. For example, if you have to be a toilet cleaner, I think there will be very few takers for those posts, and invariably you see this even in the contract jobs, etc. Invariably you see that the people who are sweeping the streets, who are collecting the garbage, etc. These are always persons from the scheduled caste communities. So the thing is, in terms of Article 16, as I mentioned, it is the keywords are equality of opportunity. And again, Justice Fazil Ali, in his concurring opinion, noted that equality of opportunity under Article 16(1) entails the removal of barriers faced by, so it is not just about it is about providing a level playing field. To provide that level playing field, you have to remove barriers faced by certain classes of society. They cannot be denied the right to equality and relegated to suffer backwardness only because they do not meet certain artificial standards set up by the institutions. Again, as I said, these standards are often standards that are set from a framework of mind of the dominant castes and classes, and therefore it is important to offset, to kind of to disperse this kind of dominant frameworks through these processes of reservation. So what's the current reservation policy in terms of SCs, STs and OBCs? It is 16.66%. Sorry. Yeah, it is by open competition is given at the rate of 15%, 7.5% and 27%. And by open competition reservation as 16.6 for SCs, 7.5% for STs and 25.84% respectively. Reservation and promotion by non-selection method is available to SCs and STs in all groups of services. So the point is, however, this aspect of promotions, these aspects of higher education, that means very much higher education, like in terms of medical, post-graduation and medical, etc. There have been very conflicting judgments because the articulation has been that the persons have already reached a certain status because they have already reached the post of the state where they are going to apply for say doctor post graduation or doctoral posts. So therefore it is not in fitting with the scheme of the constitution. But this so these are practices that are now, these policies are now subject to are in a sense still subject to litigation, because different judgments have come out with different policies, and it is also the case that it is also the case that when there are there is always because as I pointed out in the last lecture, there is a large number posts that are reserved, but the world fails to understand that there has been historical backwardness. There has been, you know, and even when the reservations have come because of historical backwardness, communities have not been provided a space within that, have not been provided the reservations that are stipulated. So there is the backlog. So in the face of all this, it almost seems as if there is a disproportionate share of there's a disproportionate reservation, but the truth of the matter is these underlying aspects which are not adequately discussed. So here I will stop and leave it open to you for discussion.
Thank you, ma'am, for an erudite and enriching session. Now I request Advocate Dr. Shalu Nigam to share her remarks.
Thank you. Thank you, you know, to all the speakers today. We have an important day today, and we have, you know, two very important, you know, presentations. The one being made by Professor Aruna and Nikhil Dey, and it talks about, you know, the pro-people, you know, policies and rights and the right-based approach and their experience of, you know, making of the RTI law and making of the health law in Rajasthan, as well as the national level, the kind of steps they are taking. And the second presentation by Dr. Albertina was very important presentation. She continued with her, you know, last you know, presentation about where she talked about the concept of equality, equity, and non-discrimination. And today, we learned about all the articles which are there in the Constitution, apart from Article 14, Article 15, 16, 46, and you know, Article 335 and 341, which talks about the definition of like who is a scheduled caste, who will come into other backward class category, and also the Indra Sahani judgment, and you know, the creamy layer, and you know, the other kind of like she explained the very important provisions. But one question I have is that, you know, you speak about the you know, how the reservation has been fixed in the government departments and the various posts, and but we still see that a lot of the posts are lying vacant. If you talk about, you know, specifically those reserved posts, those are lying vacant in the government departments. And also if we see the enforcement of you know, these provisions, we made this provision 75 years back when Constitution was made, almost like, you know, so many decades. But then at the ground level, still we find that, you know, a lot of discrimination is happening. If you talk about in terms of even in the schools, like their news items which says that even in the schools, the children are being discriminated because they belong to a particular section or category. And even, you know, in terms of, you know, various other things, discrimination, they're not allowed to go to temples, or, you know, not allowed to use other public provisions. So in terms of course, one thing you said is like going to the court, but, you know, not all people could afford to go to the court. So in terms of enforcement, you know, what are your thoughts? Like, you know, what should be done?
So I think I would go with what the previous speaker said. There is nothing that can replace a movement and struggle. And it is important that the sections that have been that are being continuously marginalized should take the lead. And it is important for the larger movements, that is the human rights movements, the various movements, which may have components of these sections of society, to back that the movement, the struggles to the hill. Because when that happens, the government will realize that it can make a difference to the votes, to the number of votes they get or do not get. And that will make that difference, because that groundswell will have that kind of impact. So, but even as you do that, one has to, unfortunately, we live in a society where you can't only have the movement without corresponding changes in the law and in the legislation and in policy and in the constitution, not constitution because the constitution has provisions already for it, but without the corresponding changes, amendments, or mandates from the court that this is how you got to interpret these provisions. So the thing is that needs to be on board, because many times what happens is, due to populist response to the demands, people make the government makes assurances. Especially you will find that in the run up to elections, and you'll hear that some of that now as the elections are coming. So the point is that those promises are not backed by legislative changes the moment the persons who made the party or the coalition that made those promises comes to power. So what we have to remember also is that mobilization, organization, and struggle is key, but that mobilization, organization, and struggle should not stop when the assurances are made. It has to move on till those assurances are translated into written documents, because the government is not a person. So it has a certain and you cannot say, oh, you had said this, now you have to do it. You can say that on the street, but in terms of the law, if you want to implement it, it has to translate into written assurances and passage of whatever necessary laws or amendments or necessary administrative circulars to make sure that certain implementation happens.
Thank you, ma'am. Now we'll take up questions from the audience. Charu, would you like to unmute and ask your question?
Yes, thank you. Thank you, ma'am, for your presentation. I'm thinking more on the actionable aspect of how someone who feels.
I can't hear. Sorry. Can you be a little louder?
Yes, sorry. My question is more towards an act. Can you hear me now?
Yeah.
My question is more towards an actionable plan from the victim's aspect, who feels that he or she has been discriminated. So what evidences should they accumulate? For example, if they are in a police station and they just are, I don't know, or someone just discriminates against them, and they want justice for that. But what evidences would court accept as strong evidences that could help them in the case? Yeah,
so now, for example, when it comes to reservations, what we had done was to ask for copies of the rosters, because the university kept saying, for example, here that we are going by the reservation system, and then there is supposed to be an L-shaped roster. So the thing is, they were saying they were going by the roster, and they were not. First of all, they were not going by the kind of roster they should have gone by. Second, so that information we accessed through this great legislation under the Right to Information Act. But even there, you know how it is that even if you have a Right to Information Act, you don't immediately get it. You have to chase it. But a lot of information was obtained by organizations like ours, as well as by the individuals. Often the particular individual who's facing the problem does not apply, because then it means that even if there is success with that intervention, that person will be sidelined because they do not like the fact that intervention was made. So therefore, that is usually the case, that somebody who's not going to benefit from the intervention that is made applies for the necessary information under the right to information. This is when it comes to reservations. Okay, to show how the reservations are not being made in keeping with the legal provisions and the constitutional mandate. So this is how that works. Also, another way is because not everybody can go to the High Court, etc. So another way in which this can be dealt with, and we have done that with some level of success in Goa, is to go to the State Commission for scheduled caste, scheduled tribes, because then the commission, because the procedure is not what shall we say, complicated, like in a legal process, you have all the red tape that is involved, whereas this process is a little more accessible, and there are on the bench, so to say, I mean, as in the people you appear before, the people are persons from the particular communities, and who are in a position to understand the sentiments of the issue, apart from the legal provisions of the issue, and who are specialized to and supposed to be equipped with the knowledge of the law on these matters. So therefore, that also becomes, in terms of accessing, okay, it becomes a easier way. Sometimes it can also be a way to gather the information, because if you can't get it, you can get it from the commission, can ask for that information, since you have said that this is what it is, and that you may not have all the information. So the commission, the other side will have to say that, look, here is my information, and they're not entitled. There's no entitlement to as many reservations. That is one way. Another way that has also been tried is getting some member of the Legislative Assembly or member of Parliament. With us, it has not worked as far as member of Parliament is concerned, because there are just 2 members of Parliament, and there's so much that they have to raise with reference to the state in the Parliament. But what we have done is to ask a member of the Legislative Assembly to pose a question, from which they are supposed to, you get the answer during the assembly session, so because then you get all the information which you don't easily get. Even on the right to information, you have to chase it, etc. So here they're bound to give answers to those questions. So that these are ways in which we've tried to put together the evidence in terms of to what extent there are reservations, how they've gone about with the reservations, etc.
Okay, thank you, ma'am, for your answer.
Thank you, ma'am. Now I request Shalu ma'am to give her closing remarks for the session.
We also have a question by Manseji. Manseji, would you like to go? You have raised your hand. No?
Savleen Kaur has raised her hand.
Okay, Savleen, go ahead.
Am I audible?
Yes.
Ma'am, you discussed how government should provide for the economic interest of the disadvantaged sections, whether it be financially or maybe through reservations. So with regards to that, the government has started various conditional cash transfer programs like before, and they tend to improve the socioeconomic conditions with respect to health and education. However, the state itself lacks the provisions of schools and hospitals, because when the demand begins to gain traction, we do not have enough supply side resources. So how do you think in situations like these with limited resources can inclusion be made more successful?
So I think that it has to be clear that when there are lesser resources, the resources have to be distinctly applied to the backward, the marginalized sections of society. That has to be clear in terms of the budget policies, the budgeting, actual budgeting, and therefore, they cannot. For example, we always pose these things, these questions. You'll have a huge samadhi in honor of a dead politician from the ruling dispensation, which is costing crores of rupees. Which amounts could have been set aside for this. So the discrepancies in the way the budgets are allocated, if they're crying poverty, then we have to point to these, and these has to be very clear that this is non-negotiable. It is like, when the election commission calls for somebody to be to serve in the election process as a returning officer, etc., you can't say, no, I don't feel like coming for it, etc. Unless you give very, very serious, cogent reasons, you cannot refuse. It's that serious. So a government department can't say, no, I won't spare my officer for that election commission. So there are certain kinds of prescriptions which are very hard and, which are very, very, what shall we say, very, very coercive prescriptions, in fact, which need to be there in these sections, because otherwise you will always have, given the inlaid, embedded discrimination in society, you will always have a situation where people will try to see how to get around it on some pretext or the other.
Thank you.
Mansi has still raised hand. So if you have a question, you can please unmute yourself, or you can type it in the question and answer box.
Right. So, ma'am, if you have anything to add, Shalu ma'am or Albertina ma'am, to end with.
Yeah, I'll just just the last thing. Now today we have learned that laws and public policies, how they are being made, and what are the challenges we face, and in the enforcement and implementation, and how can we create a system of transparency and accountability if the laws and policies and the constitutional provisions are not working. How as citizens we have to really work hard to ensure that that our rights are being protected, and so I'll just end with this famous kind of words we use, that is agitate, organize, and educate. That kind so we have to educate ourselves, we have to organize ourselves, and we have to agitate for our rights. And with this, I would like to thank all the speakers and all the participants for having a wonderful discussion today. So
thank you for the opportunity to interact with the students.
Thank you, ma'am. Now we'd like to go for the vote of thanks. As we have come to the end of day 9 of Law and Public Policy Youth Fellowship and Online National Summer School Program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 9 session, Professor Aruna Roy, Nikhil Dey Sir, and Dr. Albertina Almeida, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you Monday, that is 3rd July at 11:30 a.m. for our 10th day of this certification course by distinguished experts, Advocate Dr. Shalu Nigam, Advocate Audrey D. Mello, and Dr. Kaustuv K. Bandhopadhyay. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI #WebPolicyTalk and #WebPolicyLearning. Wishing you a good day. Thank you.
Thank you. Thank you, everyone. Thank you, Albertina.